When a government wants a lawsuit to disappear, its first move is almost always the same. Ask the judge to throw it out before anyone ever testifies, before a single document is turned over. This week, in Los Angeles, the government tried exactly that, and it failed. A federal judge refused to dismiss the civil rights lawsuit accusing immigration agents of stopping people because they look Latino, and of using force on people who were already complying. And then, 2 days later, that same judge did something bigger. She signaled she may be about to put rules on the raids themselves. Tonight, a case the government tried to kill on paper, and what happened when the judge decided it was going to live. Let me be precise about what this ruling is and what it is not, because that precision is the whole job here. Denying a motion to dismiss does not mean the judge found the raids illegal. It means something narrower and earlier, that the accusations, if they turn out to be true, describe something a court is allowed to hear. Judge Frimpong put it plainly in writing, ruling that, quote, "The accusations are enough for this case to go forward at this time," and she denied the dismissal in full, crew. No claims were thrown out. The core charges all survive: that agents ran stops and detentions driven by arbitrary arrest quotas, that they singled out Latino communities by ethnicity, and that they showed up with weapons drawn and used force on people who were already compliant. Who is bringing this? 5 individual Latino workers, joined by groups like the United Farm Workers and the Immigrant Defenders Law Center, who sued the Department of Homeland Security back in July of last year. The government wanted this gone. The judge said it gets its day in court. Now here is the part that turns a procedural win into something with real teeth. 2 days after refusing to dismiss the case, Frimpong held a separate hearing on whether to issue an order restraining how these arrests are actually made, and she tipped her hand. In a tentative ruling on Thursday, she said she is inclined to order that agents can no longer arrest someone without a warrant unless they have first made, quote, individualized, pre-arrest probable cause determinations of flight risk. In plain English, you cannot just grab someone off the street on a hunch. Federal law already says you need an actual reason to believe that specific person is about to flee. And why does the judge think that rule is being broken? Because the plaintiffs' lawyers pulled 113 arrest records and found that nearly 80% of them contained no flight risk assessment at all, or just recycled boilerplate. That is the evidence that moved her. Now, this is still tentative, not final, so hold it as an inclination, not a done deal. But it is a judge looking at how the raids are run and saying, out loud, that the law may require far more than agents have been doing. Fair shake, because a good case demands you hear the other side and the hard history. First, the government. The Department of Homeland Security rejects this lawsuit entirely. In a statement, the department said its agents are focused on protecting the American people, not, in its words, entertaining performative outrage, and pointed to victims of crimes committed by people in the country illegally. That is their position, and it belongs on the record next to the plaintiffs. And second, the part that should keep anyone from spiking the football. This same judge has been here before and lost. Last year, she issued an earlier order barring agents from stopping people based on their apparent race, their accent, or where they were working. The Supreme Court stayed that order, 6-3, on its emergency docket, and let those stops resume. So understand exactly where we stand. The government has already beaten one of Judge Frimpong's orders at the highest court in the country. What is different this time is the ground she is standing on. Not the racial profiling question the Supreme Court already touched, but a narrower, older rule about warrantless arrests and flight risk. So here is the verdict, and what to watch. In a single week, a lawsuit the government asked a judge to erase instead cleared its first real hurdle, and then watched that same judge signal she may fence in the very arrests at its center. That is momentum, and it is real. But keep both hands on the wheel, crew. Surviving a motion to dismiss proves nothing about guilt. It only earns a trial. A tentative ruling is an inclination, not an order you can enforce. And the last time this judge tried to constrain these operations, the Supreme Court's shadow-docket undid her in a single unsigned paragraph. So the thing to watch is not the headline that the judge is, quote, cracking down. It is 2 colder questions. Does the tentative flight risk ruling actually become a final binding order? And if it does it survive the trip up the appellate ladder that sank her last one? The case is alive, and the tactics are finally on trial. Whether that changes anything on an actual Los Angeles street is a question 3 higher courts have not yet answered. I'm Madeline, and this is Pixel Politics.